Hi guys, welcome to our channel, or welcome back if you're one of our subscribers. In this video, I'm going to talk to you about if you've received an opinion from the Board of Veterans' Appeals, or if your case has gone to the Board of Veterans' Appeals, what to expect from the decision, how to read it, how to understand it, how to understand what denied, granted, and remanded may mean. So stay tuned, let's talk about it. Okay, so if you're new to this channel, I want to make it clear, I'm an attorney, but I'm not your attorney. This is a full disclaimer. The information I provide here is for informational purposes only. This does not represent attorney-client privilege. I'll leave some information in the description box about some attorneys that can represent you, or some veteran service organizations that you may want to inquire about helping you with your claim before VA. Okay, I'm going to give you a short background about what the Board of Veterans' Appeals is, what their purpose is, and how it applies to you as a veteran. So when you apply for veterans disability benefits, or any kind of benefits actually, you apply to the regional office. What usually happens is the regional office may deny you, or they may grant you for certain things, but not the full amount. You appeal that. The place above the regional office is the Board of Veterans' Appeals. So the Board of Veterans' Appeals reviews the regional office's decisions and then makes a decision on their own, deciding whether the decision was correctly decided or if it needs to be corrected. So that's how you would end up at the Board of Veterans' Appeals. Also, just like the board reviews the RO's decisions, there's something above the board that reviews their decisions. So that's called the United States Court of Appeals for Veterans Claims. We call it just the court. If you don't agree with that, you can appeal to the United States Court of Appeals for the Federal Circuit. And then the Federal Circuit gets reviewed. If you even go above that stage, it's the Supreme Court. A lot of cases don't end up going that high. There are cases that do, but most of the cases either end up at the court or the Federal Circuit. So I just want to let you know kind of the hierarchy: RO, board, court, Federal Circuit, Supreme Court. So that's the order of events. That's the hierarchy of if you want to appeal, you're not satisfied with the decision that you get from the regional office. Okay, so I printed out an actual decision from the board's website. If you want to just go there, it's www.bva.gov. And you scroll down and it says search decisions, and you can put in whatever your issues are, and you can kind of see what some of the decisions have been in the past. Full alert that just looking at other decisions, you find some decision that seems similar to your case. Just be aware that board decisions are not precedential. What that means is that one judge at the board can look at one set of facts and decide one way, and they can look at the same set of facts and maybe decide a different way, or they may not include all the same facts and decide a different way. So I don't want you to go on the decision, the website, and print out a decision, which is what sometimes people do. They print out decisions like, this case was just like my case, so it should be decided the same way. Usually there's something that factually is different from the case that you're talking about versus the case that you're citing to, and therefore you may get different results. The judges may consider another judge's opinion, but in all reality, they look at each decision de novo, meaning anew. They look at the facts of your case, they look at the law and how it's applied to decide whether your case is warranted to have a denial, a grant, or a remand. So keep it in mind. I don't know if it's necessarily helpful for you to see other decisions, because there may be facts there that are not similar to yours, which would influence whether the decision would be the same as yours as well. Okay, so I printed out one of the decisions from the website just so I can use it for reference purposes. I'll try to put it on the screen so you can see it as well. But it's redacted, so it doesn't have any veterans identifying information on it as the top of the decision or within the decision itself. Usually what the board does when they put it on the website, they basically scrub it up, any identifying information so that you can't tell which veteran this was, but it also allows you to have some transparency that says this is the decision that the board has issued so that you can review it. So I'll give you a little clue. This decision was issued in January 24, 2022, and is based off a decision that was issued under the old system. So right now the board is reviewing decisions under the legacy system, which is the old system, and then the Appeals Modernization Act, which is AMA system, which is supposedly a faster way of veterans getting through the VA compensation benefit system. So the decisions are going to look differently because there are different laws that are applicable to each one. So if you had a decision that was issued by the RO before 2019, it's going to be used, the legacy system is going to be used. If your decision was issued after 2019, the AMA system was used. And based off of either one of those, it's going to tell you, how fast your claim has moved, and then what evidence the board can consider when deciding your case. So that's very important because the legacy, in my opinion, the legacy version may have been slower, but allowed the board to develop your claim a little bit more if they found that evidence, is missing this, let's go ahead and send it back and find this information for the veteran. It allowed that, versus the AMA is based off of a quick, speedy into the case because the veteran basically says the RO just got it wrong. It doesn't allow a lot of outside development like the legacy plan did. So some people like it, some people, there are some flaws within it. So I just want to make sure that's clear when you're reading the decision, depending on whether it is, the board usually says it in the introduction, whether this was reviewed under the legacy or the AMA. Okay, before I go any further, comment below if you are a veteran that had applied for benefits. Let me know what branch of the military that you served in. We like to honor our veterans. Thank you for your service. So comment below and let me know if you are in the stages of you've had the RO decide your case. Are you already at the board? Did you just get your decision? Let me know so we can kind of see where our viewers are. Okay, so the decision that I printed out actually has several issues, was part of the case originally. This is for increased rating for a mental health disorder, post-traumatic stress disorder, PTSD. They also had the issue of earlier effective date. It also had the issue of entitlement to TDIU, which is total rating based on individual unemployability, and also for dependents educational assistance, DEA benefits. So they had a lot of things going on in here. The new way the board has been issuing decisions, the old way was like they had the issues at the top and then you had to read through the whole decision and go to the last page and find out what the order was. And the order would be like, this is what the board decided. In the last couple of years, the board has changed the way it's structured its opinions to make it more veteran friendly. And so now they put the order right on the front page. Some judges may still list the issues just so you're clear about what they just, what was before them. But then right under that, it has the order that says entitlement to a higher rating of 70% is either granted, denied. So you know right away what happened. You don't have to go kind of looking for it back at the back pages because some of these decisions can be quite lengthy and the veterans didn't know that the final answer was on the last page. So keep that in mind when you're looking at some of the decisions, especially in the more recent years. They probably have it structured a little bit differently, hopefully easier for you to read as a veteran. So when you have a board decision, there are three things that the board can do. It can deny, it can grant, and it can remand, right? So deny can mean, okay, whatever relief you ask for, whether it be service connection or increased rating or waiver of debt, whatever it is, the board denied it. The second one is granted, right? And granted can mean a couple of things, right? It can be flat out granted. You ask for service connection for something, the board grants it, that's a full grant. If it's an increased rating claim, let's say you said my back got worse or my knee got worse, it could be the board has granted it in stages, meaning like, okay, yes, we see your knee or your back has worsened, but it wasn't showing that it really worsened to a certain date. So it's granted to that extent, but before this date, it's denied. So you can have some of those things called stage ratings. And then you can have something called remand, which means that the board says, well, we can't really decide this case right now because we don't have enough information. And we want to make sure the record is developed enough before we say no or yay. So you have those kind of dispositions when you're looking at the decisions. And so a remand doesn't mean that no forever. It just means we have to see what we can do before we can decide whether yes or no. Sometimes that may be in the veteran's favor because they may remand it to the regional office for further development and they may find some information, some evidence that is favorable to your case, and then the RO will develop it and may grant it while it's back at the RO, or the RO developed the information and said no and send it back to the board may say, well, this new information changes things and we can grant it based off this new information. So keep that in mind when you're just looking at the decision. It says, okay, Is it granted? Is it remanded? Is it denied? Is it all of them if you have several issues before the board? Okay, I want to make it clear that in the board decisions, the board does not have to talk about every little piece of information that has been submitted through the course of the appeal, but they do have to cite to it if they're going to deny it, to say, like, this is what we depended on when we denied it, right? So that's to give the veteran an indication of what was the reason why it was denied. It doesn't have to list every single piece of evidence that was submitted. So if you say, oh, the board didn't mention this and this, it may not have been significant into the final disposition of the case, but it doesn't mean that the board did not consider that evidence in its decision making. So keep that in mind to not get caught up in that sense. I mentioned before that there are two types of dockets. It's the legacy docket and the AMA docket. I'm going to talk a little bit more about the AMA docket because that's the more recent one, and that's the one that I think is sometimes a little bit more limiting as far as what the board can consider when it's looking at your case. So with the AMA docket, you can actually have the case taken up to the board and say, hey, the RO decided it wrong, and you can have it taken up to the board pretty quickly after you get a denial from the regional office. What you can decide whether different lanes you want to go into. Do you want the board to decide based off a direct review, meaning the board is limited to the evidence that was received up until the time the RO issued the decision and nothing else, because you're saying basically based off the information the RO already looked at, I should have gotten a grant. That's one lane called direct review. It's also another lane that says evidence review, saying, here's some more evidence. Look at this evidence plus the evidence that was already of record that the RO reviewed. And board, based off of this information, you should be able to grant the benefits that I seek. That's the evidence lane. And then the third lane would be the hearing docket. And that basically means the board, I would like to have a hearing before a board member so I can explain, offer some more argument, perhaps also enter some information, some evidence, and then I want you to consider that plus the old evidence in deciding my case, right? So those are the three lanes that you can choose if you want to have when you submit your notice of disagreement through AMA, you can have it basically taken straight out of the RO's lap and put into the board's lap to review right away. As I mentioned before, there are some limitations to this because the board cannot usually develop and remand back for development if it needs to be, if it's not for a pre-decisional error. So it means that if there wasn't some error that was done before the RO issues the decision, up until the day it issued the decision, the board cannot send it back for anything else. You can't mention something after the RO's decision and say, this is why you should send it back, because that means there really wasn't an error in the RO's decision. It means that you want the board to consider additional information that the RO hadn't even thought about. And so that's really not an error on the RO's part. Now, if you mentioned something before the RO issued the decision, let's say you told the RO, I had private treatment records at this clinic, and the RO did not send for those, that is a pre-decisional error because it happened before the RO issued the decision, right? So then the board will be able to send it back to correct that pre-decisional error. However, if you didn't mention any private treatment records, the RO says denied, and then after the denial, you say, hey, wait, I had some private treatment records at this clinic, that is not a pre-decisional error, and under the Appeals Modernization Act, AMA, the board cannot remand it back to get those records because it's not a pre-decisional error. The board can only consider the information that is of record at the time of the RO decision, and if it's not enough information to grant, the board may deny the case. So keep that in mind if you want to take that route of, I wanted to be expedited, make sure that whatever the information, the evidence that was before the regional office's decision is sufficient to say, yes, anybody else looking at this will be able to see that this is a clear grant. Okay, so what if you read the decision and it says entitlement to a higher rating greater than 70% for PTSD is denied? What can you do? What are your options? As I mentioned before, the hierarchy, you can appeal this to the court, the United States Court of Appeals for Veterans Claims, and say, hey, I need you to review this case and decide whether the board was correct in this decision. There are attorneys that can help represent you. Many of the attorneys that represent veterans before the court only do it for that limited purpose of deciding whether there is an error in the boards, whether they didn't find something, whether there was an incorrect conclusion of law. And then they basically, if they can convince a court that there was, they send it back to the board to correct the error, but usually that attorney doesn't also represent you back before the board. I would have a word of caution for appealing board decisions. Make sure it's not a matter of just like a different interpretation, because the court can't basically go against what the board has found. They're reviewing it based off of the findings that the board made and decide whether the law was correctly decided, unless there's like some clear error. If the board has explained themselves and said, this is why we decided this way, and done a good job of explaining themselves, the court is less likely to reverse the decision and say, hey, this is wrong. Also be aware of that even if the lawyer that represents you before the court gets the court to send it back to the board, does not mean that the board, once it receives your case back from the court, will also grant your case. It just means that the board may have to better explain why your case is still denied. So I see some veterans get a false sense of hope from attorneys that represent them at the court level, because they said, hey, we won at the court level and it's getting sent back to the board, but it doesn't always mean that it's still going to be a green light for them for a grant. So keep that in mind and decide whether it's worth your time. Usually the attorneys that represent you at the court, they don't charge you in the sense that you have to pay up front, but they get attorney's fees if they win, as far as this, if the court says, yeah, there was some error, they win. So they're going to get their money, but you as a veteran still may not get your past due benefits if the board ends up saying still no when it's sent back. So be aware of whether it be worth your time. Some of the attorneys out here represent veterans just at the court because they can find little nitpicky things that the board didn't say, but they know that at the end of the day, the case is probably still going to be denied. Sometimes they're not honest in representing that fact to the veterans, and because they're getting paid regardless. So keep that in mind if you want to take it further, if you received a decision from the board and been denied. So obviously this was a high-level review of a board decision, but if you have any specific questions about it, comment in this comment section below so that we can perhaps do another video that specifically talks about that. As I mentioned before, I cannot represent you, but I can perhaps provide some guidance to you or point you in the right direction for somebody that can help you. Thank you for your service, and thanks for watching. We'll see you in the next video.